Alrighty, so this is our monthly ACE classes brought to you by the Builders Association of the Blue Ridge Mountain. Today we have Anderson Ellis with the Van Winkle Law Firm talking to us about moving past the handshake. These classes are brought to you and sponsored by 84 Lumber. So I'll let Anderson go ahead and start talking to us if he's ready.
Thanks, Jude. Thank you, everybody, for being here. I am Anderson Ellis. I'm an attorney at the Van Winkle Law Firm here in Hendersonville. If you're not familiar with my firm, we are the largest law firm that is headquartered west of Charlotte. So it's a little bit of a mouthful, but we've been around for 100 years. Our home base is in Asheville, but we have our office here in Hendersonville on Main Street, which is where I work from. I am a Hendersonville native, grew up here, and I'm really proud to be back here doing business work. That's what I do. I only do business, corporate work, transactions, some light real estate contracts, but mostly I do exactly the kind of things that we're talking about today in this class. I do contract review, helping people prepare for exiting the business, purchasing a business, all of those kinds of things. So I'm glad to be here. Thank you to Megan and Jude and Sarah Cosgrove for inviting me to be here, and thank you all for taking some time out of your morning. I will give you a few heads up things at the beginning. So I have sort of 5 general topics that I think we're going to talk about today. I'm starting with the ones that are, I think, more important, but I want everybody to understand that the purpose and sort of the reason for this presentation, I think the most utility, is for those companies, as the title implies, that are growing, and they're growing from a small scale, and they're looking at what kind of things do I need to be aware of as I grow. There may be on this call, maybe certainly as part of your membership, folks and companies that are way past this point. So some of the information I'm going to cover may be really elementary, but I also recognize that there's a lot of people I work with that are at the stage where they may be operating on a handshake. They may be doing deals, just based on verbal contracts. They may be set up as a sole proprietor with a DBA on their own Social Security number, and they're wondering, what the heck do I do as I get bigger and I want to hire more employees and I want to do this, and how do I protect myself? That's what this information is really intended for. It's going to be at a real basic level, but for each of the topics as we go through them, I want, we've only got 13 people in this presentation. So I hope that if you have questions after each one, I'll ask if there's questions. There'll be some time at the end if there are questions. I have to give the lawyer spiel at the beginning and say, nothing that I'm presenting today is intended to be accepted as explicit legal advice, and you should consult with your legal counsel if you have specific questions relating to your business. The information presented is for general purposes only, and I'm glad to answer questions that come up. What I would say is that I can't answer questions that are like, hey, in my business, I have this guy who is doing blank, because that would be legal advice. So I can answer general questions, and I'll be glad to do so for each of the sections. I have no idea how long this presentation is going to take, because I just kind of made notes on things that we're going to talk about. So if we start running out of time, the things at the end are not, we're not going to get quite as in depth about, but we'll see. And hopefully we'll have some time at the end for general questions. So we'll go ahead and get started so that we can get into the first group of topics. Let's see if I can make sure that this works. There we go. Okay, so generally speaking, when we're talking about the basics, I would say that if you're a company that is working in the construction, home building, service provision fields generally, there's a few things you want to think about when you're growing. One of them is going to be your contracts, and we're going to get into some specific contract clauses, language that you may have heard about, not really sure about, things that have become really relevant in our area recently. The structure of your business, what it is now, what it should be, what it should look like potentially for the future, and what your plans are. Dealing with subcontractors and owners, both contractually but also practically. What are some things that you should at least be aware of that might help to avoid issues or might address issues that have already come up. And then finally, sort of generally speaking, liens, which would be the legal rights that y'all in your industry might have, or potentially have to sort of defend yourself against if things do start going sideways. So these are the 5 basic topics that I hope that we'll at least be able to touch on. Like I said, I don't know how in depth. I really do want to go pretty good into contracts and structure. The last 3 topics we may end up hitting a little lighter, but hopefully you guys will have some questions when we get there. Okay, let's talk about contracts. So when the association and I were talking about this program, one of the things that I know is of really particular interest right now is, in the wake of Helene, and then coming off the tail of COVID and everything else that's gone on in our area in the last 5 years, contract provisions have become really important, especially things like indemnification, force majeure, changing timelines, inability to finish projects. Those kind of things have become really important. And while they were always important, people have actually started having to lean on them in ways that they may not have been expecting when they initially did their contracts. And so while I don't believe that I am qualified to speak, for an entire hour on the specifics of force majeure or indemnification in the construction industry, because I am not specifically a construction lawyer, I am glad to explain some of these things, because I do think that there may be, especially for young, I don't mean young in age, but young in time of running a business, young businesses, young business owners, a lack of familiarity. I see a lot of people I talk to, and I talk about indemnification or force majeure, and they kind of know what it is, but they don't really know. So I want to hit on some of these topics specific to contracts. And I want to start by saying that the contract that you have in place with so let's assume that if you're functioning as a GC, the contract that you have in place with your owner, the owner of the property that you're working on or the project, and then the contract, that's sort of the upside contract. And then the downside contracts with your subcontractors, people that are working for you, are really, really important. But you'd be surprised at how many people say, well, but I've worked with them for years and we've never had an issue before, and we're just going to do the next project like we've done every other one. And when they come to me and say, things have gone completely sideways, and I say, send me all of your documents. And they say, okay, here you go. Contract in place, upside and downside, that you feel comfortable, what the terms are, what your rights are, what happens in different hypothetical situations, and whether that's something that you've gotten from somebody else, whether that's something that you have, the better it can be, the better for you. You'll have less issues. And so I really can't emphasize enough that one of the first things that I think you really should think about is investing time and money and thoughtfulness into your contracts. So let's start with some of the more specific the sections, the clauses of the contract that people should be familiar with. So let's talk about indemnification. Indemnification generally. I won't do a poll or anything like that and say who is familiar with what the heck indemnification means in general. But in really layman's terms, indemnification is the agreement of a party to stand in the shoes of another party in certain circumstances. So, for instance, in certain circumstances where a contract says that this set of things is your responsibility and this set of things is my responsibility, indemnification would bridge those two things to say, if for some reason I end up having to expend cost, money, time, hire a lawyer, any kind of loss because of something that was in that bucket of your responsibilities, you are going to step up and either take care of that problem so that I don't have to expend those losses, or you're going to reimburse me step into my shoes and make me whole when I do have those losses. And that can be, like I said, that can be in the form of reimbursement of money. That can be in the form of hiring a lawyer that's then working for the indemnified party. That could be, people as simple as sending somebody an invoice that you receive and saying you have to take care of this invoice because it occurred before a certain date or in a way that it was your responsibility. And that is indemnification. Indemnification is saying you're not going to have any losses for things that I am responsible for. In y'all's world specifically, indemnification is important because you got a lot of people who are responsible for a lot of important things. You've got electricians and you've got plumbers and you've got a lot of different moving parts, especially if you're a GC who can, sort of, it's like the human body. Like there's so many different systems that are working at once. And if any of them start going haywire, they all ultimately will affect each other. And then sort of the brain, the GC, the one in charge, is going to have to take care of everything. So I think indemnification is important because that is going to be the clause in your contract that allows you to say, hey, I have been, for instance, I'm the GC, I've been sued or I've been threatened or I've expended losses covering things with the owner because of things that you didn't do properly or that were your responsibility. In our contract, my contract with you, you've indemnified me against these things because they were your responsibility. Other than just a simple breach of contract that you've breached your obligations to me, we have this additional provision in here that specifically says, if you have breached these provisions, you are going to pay me, make me whole, reimburse me. So indemnification is important when you've got other people that are working on your behalf and you are ultimately responsible either to a third party or you just want to cover yourself with another layer of protection to say, even if I end up having to spend money, I've got this pocket that I can go to and try to get it out of. One thing I will warn about indemnification, like I just said, it's a pocket. It's only as good as the pocket that it's coming out of. So you cannot rely on indemnification alone. Well, I'm indemnified by my subcontractor if anything goes wrong with his project, that if the owner comes after me, I've got another pocket to go after. That's fine. But if that subcontractor has no money or they don't have proper insurance coverage or they don't, whatever, go out of business, that indemnification is worthless. It's worth nothing. So make certain when you've got these contracts and you've got, and you're indemnified, or you're even providing indemnification to others, that you do have adequate liquidity, financial stability, insurance coverage that would provide that indemnification to actually make it worthwhile. I'm dealing with a company right now that has been alleged by a owner to have improperly done their work. They put in a claim with their insurance company. I'm not an insurance defense attorney, so I've passed it off because they accepted the claim, but they put in a claim with their insurance company. The first question their insurance company asked them was, do any of your subs that were part of this project provide indemnification? Look at the contracts. If they had, that would have given the insurance company opportunity to go after those companies as well to try to recoup whatever money they spend. In our case, again, they didn't have contracts with the subcontractors, or the contracts were so simple they didn't provide indemnification. And so now the insurance company is probably going to have to pass along the money that they spend in losses and premiums and all that stuff. So subrogation and indemnification go hand in hand. But yeah, so that's what indemnification means generally. Force majeure especially has become really important around here in the wake of Hurricane Helene. Force majeure is, of course, the provision that allows for a change of contract due to situations beyond your control, acts of God. Those would be the pandemics and the hurricanes and the tornadoes and floods and things like that that are not foreseeable, that would allow for changes to the contract, delays, extensions, additional costs and things like that, or even potentially termination of the contract. Force majeure, I will tell you that in the wake of Helene, I had probably 100 inquiries from individuals or companies that I work with saying somebody is either suing me or I want to sue somebody because they were not able to follow through with this service they were going to provide, and it was supposed to be provided on October 1st, and it wasn't provided and now I want my money back, or they were asking for their money back and I don't know what to do. Force majeure is one of those things that we could probably spend an entire afternoon talking about. It's very complicated. It's very nuanced. But generally speaking, in your contracts, you want to make sure that you do have a provision that allows for some flexibility of the contract based upon things that you have no control over. If there is a pandemic, if there is a serious outbreak of something that limits your workforce, if there is a tornado in the town that you're working in and now you either can't do the project or the project's been damaged or nobody can get to work. I mean, you want to make sure that you have at least the argument, the defense to throw up there to say this qualifies. And you want your force majeure clause to talk about things like, does it delay the execution of services? Does it terminate the execution of services? Does it provide for additional costs up to a certain percentage? I mean, force majeure clauses can be one sentence, or they can be 10 sentences, or they can be a whole page. It really is sort of depends on really how detailed you want to be and how you've been burned in the past. So, but force majeure is something that is important. It's important to understand. It's important to have in there. And I wanted to make sure I touched on it. Termination. This, again, seems very straightforward, but you'd be surprised. You want to make sure that in your contracts, you have the right to terminate. You want not just your client, but you want to have terms in there that allow you to bail on a project if there is something going on that warrants bailing. Now, you have to understand that the termination clauses are going to have, many pieces to them. So what is owed at that point? How do we account for the fact that the project has to be picked up by somebody else from that point forward? But you want to make sure that if you end up with a customer that's completely unreasonable, if you end up with somebody that simply will not follow through with the terms of your contract that you've agreed on, is constantly changing things, is a nightmare to deal with, or it just becomes completely unfeasible or impractical for you to continue doing the project for whatever reason, that there is a termination clause that you allow for limiting what your world of damages could be. And we'll get down to liquidated damages, but what you want to do is make sure that your termination clause particularly includes those limitations on damages so that the owner or the sub or whoever else doesn't get a lawyer who says, well, I've got this whole universe of damages I could go after. I could go after hypothetical lost revenue for the next 10 years based on termination of this project. Or maybe you terminated building this building, and now because it's going to be 6 months off course, now we've got landlord tenant issues with tenants that we've signed on, and we've got revenue issues for those tenants that can't move into a building for 6 more months. And could they sue you for all those? I mean, yeah, I don't know if they'll win. I'm not saying they'll go into court and get all those damages, but they could. So you want your termination provisions to include limitations so that you can sort of know what universe of damages you're looking at if you have to get out of a project. Change orders. Change orders is really, really important. It's so much more important than I think many people give credit to. Scope creep, if you haven't ever heard that term, like scope creep is real. People will constantly change things. They'll agree on really specific terms in their original order, and then they'll change everything. They'll literally walk into a house and be like, oh man, I know I wanted that cheap tile because I didn't want to spend money on the tile, but that stuff that's hand crafted and flown in, on the back of a donkey on a private plane from Italy really is what I wanted. And so why don't we just switch to that? And then later I'm going to claim that you agreed to do that for the original cheap tile price. Okay, well, that's great that they want to upgrade what they're doing, but everything in writing. I don't care if the best you can do is email confirmations back and forth, specifically confirming the changes and the prices and numbers. You have to get things in writing. When people come to me and say, I charged them $10,000 more because we agreed they were going to pay $10,000 more for this change, and I say, where is it in writing? And they say, oh man, this was something we did on the job site. That's impossible to be able to really guarantee any kind of outcome. So change orders, having a standard change order process, having that in your contract so that they know, the customer knows, or the subcontractor knows, it's not going to be done on a handshake. It's not going to be informal. We may discuss it informally, but until we've got something in writing, you can't rely on anything that either of us have said. So change orders being in writing, important, very, very big deal. I would suggest when you get to the point where you're having contracts drafted, oftentimes when somebody comes to me and says, I just need contracts, tell me what I need. We do a whole slew of contracts. We've got if it's a one-off project, we'll have the quote form, and it will have certain terms and conditions and things that tie into the main contract. We'll have the main contract form. We'll have a change order form. We'll have the other forms at the end that come with sign off on the project being completed or move in, or the invoicing and all that kind of stuff. Like this whole slew of templates that are then used for projects going forward. If it's something where you're doing multiple projects for the same client and you're going to have a master service agreement or a master contract with separate project contracts, we'll have all of those. So seeing what kind of contracts you need and sometimes getting them all done at the same time can help you have a really consistent, strong set of terms that are known to all the parties at the very beginning. And then liquidated damages. I put that on here because it kind of ties in with termination. It ties in with force majeure and all of those things. Liquidated damages are going to be ways to calculate damages that are known to all parties up front, and it reduces the speculation of somebody being able to claim hypothetical future damages that are darn near impossible to calculate, except for that expert that they happen to bring in from Atlanta who says, I'm an expert who's been testifying in court on this for the last 20 years, and I'm able to say how much money this is worth. No, what you want to do is, if you're going to have delay provisions, or if you're going to miss a deadline, you want to have in there how much that's worth. It's worth $100 a day. It's worth $1,000 a day. Is it worth nothing? Is it worth nothing up to a certain point? Does force majeure spring some kind of, minimum or maximum delay before there is the implementation of those kind of penalty damages? Think about liquidated damages almost in the same sense people talk about punitive damages. These are ways that client, so being able, for indemnification being limited to a little bit more shaky, like timeline delays or things like that. Being able to calculate your damages ahead of time and estimate what those are going to be and know what you're going to be responsible for is important to consider when you're putting actual contracts together. And those are things that people just simply don't do when they're operating on the handshake or the email contract or the one pager that they've been using for years. So, okay, so there's 150,000 other contract provisions that we could go over. These are 5 that I picked out that are important because they're usually things that people don't hit on when they're not using a contract or when they're using a really simple contract. That's sort of my spiel for contract provisions. I will, at this point, I'd be glad to answer any questions that people have on this, knowing that there are some other sections I want to get to, but I also don't want to wait until the end and then not have time. So does anybody have any questions they want to ask now, or something to pose to the group, or sort of put a pin in it so that we can address it later? Awesome. That means I'm either a terrible teacher or an amazing teacher. Okay, so let's go to the next section. Again, I think this is a really, really important one for people that are growing. So talking about the structure of your business, let's talk about what the actual business that you're running itself looks like. Again, people that are in businesses, owners or employees or whoever's on this call that have been in business for 10 or 20 or 50 years, these kind of things are going to be set. You've probably got things filed with the Secretary of State since 1975. So this is going to be completely elementary to you. But for people who started off doing projects and they've grown and they've brought on some people that they're paying on a project basis, and now they're saying like, well, what should I be doing? This is getting a little bit bigger than I expected. This is really, really, really important. So let's talk initially about sort of the three major types of business structures and what they are. You've got LLCs, limited liability companies. You've got, I have in here inks, but those are corporations. So those are going to be your companies that end with Inc. or or incorporated or whatever, but those are corporations, for-profit corporations. And then DBAs. DBAs are going to be your sole proprietorships. Those are going to be the things that are like, Joe Johnson, DBA, Mountain Construction. I'll go backwards from my list. DBA is going to be something that is a business that you are operating, that is you, and it is tied to your social security number. And it is not a separate being, as the law would consider it. It is not a separate entity. It is you. And so whether you're operating as Mountain Construction, whether you're operating as whatever, you have a separate bank account that just has Mountain Construction on it, you open that bank account with your social security number. And you're operating on people writing checks to Mountain Construction, but if something goes wrong and you incur liability or you end up with a huge amount of debt or something like that, that's you. That is, Mountain Construction is nothing but you. And so you've put yourself, I mean, it's necessary sometimes at the beginning of a business's lifespan to do this, but you put yourself in a real exposed position, a lot of risk if you're operating as a DBA, because all of the liability comes back to you personally. There is no protection of your personal assets other than things you might do like like trusts or other mechanisms you have personally to protect your assets. Your business does not protect your assets. Your business does not protect yourself from liability that's incurred. So it's okay to start. This would be something that you would say as soon as possible, as soon as feasible, you'd want to move away from a DBA, move away from a sole proprietorship and into an LLC or a corporation. And generally speaking, from a legal side, the legal protection of a limited liability company and a corporation is the same. As long as you are operating it as an independent legal entity, you are handling the money that is flowing in as a separate thing. Even if you're the only person who owns any shares or membership interests, if you are paying yourself as if the LLC or the corporation is its own independent, standalone thing, and you are deriving income from it, and you're not using the company card to go take your family to Disney World, you can isolate the liability for the work that's done within that entity, within the inside of the entity. So that's why people set them up. They set them up so that they can say, look, as long as I'm doing this correctly, I can isolate my liability within the LLC. Now, I will say this, and I don't want to get this, again, is probably a whole nother presentation, but you need to be aware that LLCs or corporations that are wholly owned by one person in your industry specifically, who also are on the job site doing work themselves, can open up liability for that individual owner as an individual and not have the full protection of the entity. So you need to be aware, based on your specific set of circumstances, what insurance coverage you need, what other protections you might need in place if your entity itself is not going to provide that protection. So just note, without me having to get into really the weeds on this, just know that if you are an owner of a construction company and you are yourself on the job site, sitting in a piece of machinery, digging earth, the work that you are doing, if you damage something, if you do something improperly, if you make a mistake or whatever, you individually could be held responsible. Now, if you're not doing the work, or if somebody on your team does something wrong while you're there, it's not necessarily going to impact you individually. That is going to be liability that's protected by your company. If you do something that's alleged to be wrong and it's not wrong, obviously that liability isn't going to stick. If you are supervising, if you are sending people to job sites, or you're going down and inspecting and you're saying, yep, you guys are doing good, or change this or do this differently, and then you're going back to the office and you're operating and you're looking at another job site, what happens on your job sites is not going to stick to you individually necessarily if you have that protection. But when you are small enough, or you are hands-on enough that you yourself are doing the work, you can be held responsible if something goes wrong with the work that you are doing. And that is different from other employees of your company, because if an employee of your company does something and it is like they accidentally cut a pipe or something like that, and there is liability incurred, they individually, as an employee of your company, do not likely have personal liability. You as a company do, and you as an owner will not have personal liability for their mess up. But when you are your own employee and you are an owner of the company and you do something wrong, you can. So that is a really big caveat for people that are small and that are hands-on involved in their companies. And I just want everybody to know that. LLCs, corporations, the big difference to know about those, corporations are the traditional shares, board of directors, the officers, president, vice president. We have annual meetings. We have meetings of the board of directors. The shareholders appoint the board appoints the officers make decisions. The money goes up to the shareholders, and that's how a company works. LLCs were created to keep sort of the complexity of the corporation more simple, for companies that don't need it. So what you have in LLCs is you have members and you have managers. You can have different names for them. You can have a president, vice president, CEO, whatever you want to have, but ultimately you have members who are the shareholders. The members choose the managers, who are essentially the board of directors, to run the company. So you can have members that are both members and managers. You can have members that are managers. You can have managers that are not owners. You can have all kinds of things. But those are the two classes of people in LLCs, versus corporations. And just know this also: an S corp is not a thing. An S corp is a tax designation. So when someone comes and says, "Oh my gosh, you're growing and that's great," you should form as an S corp. What they're saying is you should set up an entity and elect to be taxed as an S corporation, or a corporation under subchapter S. That allows for money to pass through, and we're not going to get into tax stuff because I'm not a CPA, but it allows you to avoid certain levels of tax in your company when you derive income as an owner. But that's not a thing. You don't set up as an S corp. You can be an LLC and be taxed as an S corp. You can be a corporation and be taxed as an S corp. You have all of those options regardless of your structure. So when you're talking to somebody or you're figuring out how you want to be structured, look at the actual structure of the entity itself, as to what you want, and not necessarily how you want to be taxed, because you have all of those options, regardless. Now, I do have a hand up, so I'll let InfoCura Concrete ask a question if you have a question. I don't want to move on to the next things in this section without being able to answer.
Yes, thank you. It goes back to that scenario that you were saying with the one owner being the person that also works on site. Is that only for people that own the company 100%, or versus someone who owns like 50 and 50%, one person that owns at 50 does do some work on site, but the other person is in the office most of the times, or supervising?
That's a really, really good question. And the situations where I've seen people being held responsible personally, have been situations where there was 100% ownership. I don't want to give you the wrong answer. I'll say, for now, without, certainly we can talk off this and there can be specific details, but I would say for purposes of right now, I would assume that there probably is some sort of individualized responsibility, personal responsibility for the owner of the company who's also functioning as an employee and incurs liability for the work they're specifically doing on the job site. The premises, I mean, the principles for the owners, for the research I've done, are control of the company and the direct action and incurring of liability. So I don't believe, if I did the research, I would find that there's any difference between a 50% owner, 100% owner, 10% owner. I think the important thing is that they are an owner. So that's what I would say. Now, don't hold me to that. If we dig a little deeper into it, we may find out that no, this is just something they wanted to do to prevent single owners who are their only employee from being able to avoid personal liability. And in which case I would go, sweet, that's a really great outcome from our research. But I think without doing further research into that, I would have to assume that the triggering factor is the fact that they are an owner, not that they are 100% owner.
Okay. All right. Sounds good. Thank you. We'll follow up.
We'll hit these next pieces. Operating agreement, shareholders agreement. These are important documents. You can always go to LegalZoom and get an LLC or a corporation set up. I would encourage you, as you're growing. The operating agreement for an LLC is basically a partnership agreement, if you've heard it called that too. It is a contract between the owners of the company as to how we're going to run the company. In a corporation, you have bylaws, which are the steps on how to run the company, how somebody is appointed president, secretary, treasurer, all that stuff. But really the important thing for an owner to know about that is going to be a shareholders agreement. That's where something like a buy sell or restrictions on transferring your shares, or what happens if somebody dies or is hit by a bus or wants to exit the company voluntarily, that's where that's going to be. That's not going to be in the bylaws. The shareholders agreement is the agreement between the shareholders. So those are two documents based on however you incorporate that you want to make sure you're going to, if you do it through something like LegalZoom or Rocket Lawyer or whatever, you'll get a real basic one. It will comply with the North Carolina statutes, but it probably won't be tailored in the way you want to address whatever issues you may have with your partners. These are very important when you have more than one owner. When you have one owner, the owner can do whatever they want. Yeah, I draft single member operating agreements, but I mean, they're sort of for show. And usually they're just for the bank so they can open up a bank account. Multi-member LLC operating agreements, multi-shareholder shareholder agreements to supplement the bylaws. Those are very, very important. Buy-sell agreements, if you've heard it called that, restrictions on transfer, things like that. These are the agreements that those go in. So when you have more than one owner, even if they are your brother, your wife, your husband, your friend, your kids, doesn't matter. I would absolutely encourage you, have a lawyer or somebody who knows what they're doing help you with your operating agreement and shareholders agreement. That is the most important thing as far as the operation of your business from a really high legal level if things go wrong. What you need to know is that if things go wrong in your company, especially if you are a 50-50 owner or there is no way to break a deadlock or establish a majority, the only thing the statutes in North Carolina allow for is liquidation and dissolution. That's it. There is nothing in the North Carolina law that says, well, if you can't agree, then one of you has to buy the other one out, and here's how you establish fair market value. Nothing. You go to court, you tell a judge we can't get along, we can't operate this business anymore. The judge says, all right, here's a match, let's burn it to the ground. That's all that they can do. So everything that you want to do as far as establishing how deadlocks are broken, establishing how people can get out of the company if they want out, how things are handled if there's allegations of fraud or abuse, those things are all in the shareholders agreement and operating agreement. They're very, very important. Plan for growth and exit strategy, I'll kind of loop together. When you're thinking about how you want to incorporate as an LLC corporation, think about whether you want to bring on investors. A lot of times investors, if you want to bring in partners later, they're going to love the corporation structure because there's a lot more pliability as far as I can be a shareholder without any obligations on the board, without being an officer, without any responsibility. I could be silent. I could have Class A shares, Class B shares. There's all kinds of stuff you can do with corporations. And I will say in the construction industry specifically, for whatever reason, there's a lot of love for corporations, a lot of love for the traditional structure in y'all's industry specifically. It's not good or bad. It's a little more antiquated than LLCs, but it also allows for much more straightforward delegation of, you're a shareholder, you sit there and be quiet. You're on the board of directors, you make decisions. Here's the president, they report to you. So think about, as you're planning to grow, are you going to bring on partners who are going to get paid out in different timelines? Are you going to bring on private equity or silent investors? You probably want to have a structure like a corporation where you can do that more easily. An exit strategy, again, what is your long-term plan for the company when you're setting it up? Are you planning on running this thing for 10 years and then shutting it down? Let's make it simple. Are you hoping that this is something you can pass along to your children? Is this something you're hoping you can sell to your employees internally or list for public sale one day and make money for retirement off the sale of your company? Think about that. Think about how you want to potentially structure something with, think about how you want to potentially structure things with subsidiaries. Are you going to have a land holding company that owns the land that you're improving because you're going to purchase, improve, and flip property instead of doing it for outside customers? If that's the case, then you probably want to set up your subsidiaries in one way and your parent company in another way, and you want to make sure the tax status of those two things don't conflict with each other. So think about your plan now, how you plan to grow, and how you plan to exit as far as when we're setting this up, what can we do? And also remember, it can always change. You can always change it. If you set up as an LLC and you realize a corporate structure is better, you can convert. If you set up as a really simple corporation and you realize later we need multiple stock classes, you can do that. So everything can be changed, but it's easier if you think about these things on the front end. Okay, that's a huge amount of information that I just threw at you from a really high level. Does anybody have any questions about this slide before I move on to the next one? And I promise the next ones have a lot of information, but I'm going to sort of pick and choose because I only have like 15 minutes left. All right. Okay. Working with subcontractors. I've put some points in here. Like I said, we'll hit these relatively quickly. I know these are obviously very important to y'all. And I think that they, again, probably each of these slides could do with their own 1-hour presentation. But as far as some basic things to think about when you're working with subcontractors, if you're moving into a larger stage of your business, make sure that your contracts are very specific about pay when versus if. I mean, I know that a lot of people may have opinions about which of these is acceptable and not, and industry standard and all that, but it's important to know on the front end, are you paying your subcontractors when you're paid by the owner, or are you paying your subcontractors if you're paid by the owner? If you're a subcontractor, are you paid when the general contractor is paid by the owner, or if? Obviously, based on who I'm representing, I have a different opinion about which one of these should apply. But what you don't want to do is get in a situation where the contract, if you're a sub, you've signed a contract that said you get paid if I get paid, and then you don't get paid, and you say, well, what am I supposed to do here? And they say, sorry, I haven't been paid. You don't have a right to sue the landowner. You don't have a contract with the landowner. And it is possible that you don't even have a right to put a lien against the land. You might, but you might not have any lien rights as far as the land is concerned based on your contract with the general contractor. You may have waived your right to put a lien on the property. So make sure when you're signing contracts, you know when and how you're being paid and how it relates to the other parties in the contract. Flow down provisions, there you go, same thing. It's going to be the sort of the same thing related. It's going to be if you're a subcontractor or if you have subcontractors, binding them to certain terms that are in the higher end contracts. If the GC's contract with the owner says something that the GC is responsible for, and the GC's contract with the sub says to the sub, you are responsible for these provisions to the landowner, the owner of the property. As a sub, you want to see that main contract. You want to see what I'm binding myself to. So these flow down provisions are things that allow for obligations from the high end contracts to flow down to the low end contracts. And you want to be careful about those. If you're the sub, you want to make sure you've read everything and you know everything. If you're the GC that's in the middle, you want to make sure you've provided that information to the subcontractors if you're going to hold them to those provisions. And if you're the GC, you want to make sure the owner is aware of the flow down of some of those obligations. Lien waivers and indemnity, those are, again, going to be things that when you're working with subcontractors or you are a subcontractor, you want to be aware of. What indemnification are you being provided by the subcontractor, or are you providing to the subcontractor or the owners? What rights are you asking them to waive? What rights have you waived as a sub if you are stiffed on money? Can you file a lien against the property? You don't have any contractual privity, which is the actual contractual connection between two people with the owner of the property. So can you encumber their property? I don't know. Maybe not. Are you responsible for indemnifying the general contractor against damages from the owner if you don't finish your work? Maybe not. I mean, you want to make sure that those things are addressed. And then restrictive covenants. I don't think anybody who's ever worked with subcontractors hasn't run into this. Restrictive covenants are going to be like your non-competes, non-solicits. So when you're a general contractor and you hire out an electrician, you want to make sure that you've got contract provisions in there that say you're not going to, take on jobs with this client outside of my relationship with you as a subcontractor. If you're a GC, you're putting on a little bit of extra cheese on top of that contract to make sure that you're getting paid for coordinating with the subcontractor. But if the subcontractor finishes that work and then goes to the owner of the property and says, hey, next time you build a house, just come to me directly. We'll just do this directly. We'll cut that GC out of the middle. You want to make sure that you've got a covenant in there that says you're not going to do that. You're not going to do that with this project. You're not going to do that with other projects. Got to be reasonable. Got to be reasonable. And these are not going to be non-competes that are in the same vein as we've seen the FTC and stuff talking about non-competes with individuals and jobs they can hold. These are not going to necessarily apply. So when you hear boogeyman stories about non-competes, I'm talking about something a little bit different. And non-solicit's going to be like, if you're a subcontractor or your GC, when you expose other people to your skilled workers, you don't want them going to them and saying like, hey, stop working for that chucklehead over here. Come work for me. You want to put some provisions in there that say like, you can't hire my people for at least 1 year after the last time we worked together, because I'm not going to give you access, get a little bit of money from working with you, and then you're going to steal all my people. So you want to make sure they're not stealing your customers, stealing your clients, stealing your employees, or, and then when, obviously when you've got skilled employees yourself and you want to talk about restrictive covenants for non-competes, that's again a whole nother presentation. A little more sticky when you start talking about restricting somebody's ability to make a living. So again, really high level stuff with subs, but things you need to think about when you're growing and you're actually dealing with more and more subcontractors. Any questions on that one? You're like, yeah, I've got a million questions, Anderson, but none I can ask you right now. Good Lord. Okay. Avoiding owner disputes. Again, I'll just say you got, written contracts, everything in writing. Payment terms, and when I say written contracts, I mean change orders. I mean, everything, like I said, that's that slate of documents that you're using, everything in writing. Dispute resolution, making sure in your contracts that you've set forth, are we doing arbitration? Are we going to go to court? Do we have to mediate ahead of time? Do we have provisions in there that say, what happens if you accuse me of something or you allege that something has happened? You can't just run off and hire a lawyer and, what you want to do, because oftentimes if you're a GC, if you're a sub, sometimes you're dealing with people who have far more resources, are much bigger, maybe have done many, many, many more jobs, or have a lot more leverage than you might have, especially if you're a small company. You want to make sure that there are provisions in there that allow for the efficient and affordable resolution of disputes, or at least the attempted resolution of disputes, before somebody just jumps into something ridiculous like federal litigation for hundreds of thousands of dollars or millions of dollars in damages, and you go, good Lord, this is going to ruin me. And I never even had a chance to mediate. I never even had a chance to do anything. So arbitration is an option. It's cheaper. It's smaller. It's like a person who makes a decision like a judge, but you don't have to go to court. It also has a lot of rules. Arbitration is a really specific thing. I don't love arbitration, but I also don't love court. So it's an option. Mediation, it's my favorite. I love mediation. I love making mediation required. The Superior Court in North Carolina requires mediation in every Superior Court lawsuit. So the courts have already said that they think mediation is appropriate, and you can have pre-litigation mediation. Mediation can be done by professional mediators that are certified. It can also be done by anybody who's located in Henderson County, or I think Buncombe County too. The Mediation Center is a nonprofit that provides mediation services. I think they charge $60 a party. So there are affordable options for mediation, as long as your contracts can put into it some sort of required mediation, pre-litigation or arbitration or anything like that. It can be with lawyers, it can be without lawyers, but being able to sit at a table and talk through problems, or being able to get into an arbitration proceeding or something that is smaller scale and cheaper, can oftentimes get things resolved for a company without putting them at risk of whatever. And also remember, you've got insurance. Somebody accuses you of doing something wrong, put in a claim with your insurance company. Yeah, they charge you premiums and all that crap, and they're terrible to deal with, and I absolutely hate insurance, but you're paying for it. You have to pay for it. So use it. If they will, because if they'll accept your claim, they'll send a lawyer from Raleigh or Charlotte or someplace that they work with who will handle it. They'll negotiate a settlement. They'll pay a settlement amount. They'll take care of it. They'll pay the lawyer. You may pay higher premiums, but you don't have to deal with anything. If you deal with somebody like me and you don't file it with your insurance, we can negotiate a settlement. We can do mediation and all that, but you're paying me, and then you're paying whatever the settlement is. So just remember that insurance is there in certain circumstances to help you handle and not be buried by the possibility of having a conflict. And then I just want to say this, because people, it baffles me that people have a problem with this, but accusations, please, 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 please do not engage in public discourse with a dissatisfied customer on the internet. Please don't do that. If somebody leaves you a terrible Google review or a Facebook review or something like that, deal with it professionally. Get your lawyer engaged if you need to. Get a PR person engaged if you need to. But please don't respond and say you're an idiot and you're wrong. Please don't do that, because the only thing it serves to do is take a professional company or professional owner and pull them straight down into the mud. I have never seen somebody respond to a public accusation in a way other than, we're very sorry you're dissatisfied. Please reach out to us directly and we'll try to make it better. Any other response has negative consequences. I don't care what it is. Any other response has negative consequences. It seems impersonal and it seems cold. If you have to respond in a way that's like, we strive to make sure every customer is satisfied. We're really upset that you're not satisfied. We hope that you'll give us another chance and that you'll reach out and let us know what we can do to help. Think about going on the Better Business Bureau or Yelp or whatever, Angie's List, and seeing somebody who's arguing about, you didn't do this and you didn't do that. It looks like some chucklehead sitting in their basement running their company arguing on the internet. I mean, it's crazy. So please don't do that. And if you're inclined to do that, talk to somebody like me first so I can try to convince you not to. One minute on liens, which is like exactly what you guys wanted. 1 minute on liens. But I want to make sure you understand what liens are and what they are not in North Carolina. What a lien is in North Carolina is a placeholder to tell people that you've got an issue that needs to be resolved. What a lien is not is a judgment. It is not something that allows you to foreclose on property. It is not something that allows you to ultimately own property. It is something that sits publicly on the record when you file it with the clerk to tell anyone who is purchasing property that there are issues that are unresolved. In North Carolina, what you guys would have would be either a materialman's lien or a mechanic's lien. It's for people who've put valuable time and product onto real property. So when you build something or you whatever like that, you've put value, and if you haven't been paid for it, you can make a public filing that tells anybody who's going to buy that property or anybody who searches the court records for either the property owner's name, your name, whatever, this is out there. So it is a red flag planted in the sand to say this is an issue that needs to be resolved. It can only be filed within a certain period of time, and it can only exist for a certain period of time before you have to do something else. So the time periods for you to know is that 120 days. 120 days after the last time you went to the property, the last time you put value on the property, the last time you brought materials to the property, did work, that's the time frame in which you have to file your lien. And it only exists for 180 days after that same point. So 6 months. 6 months, so 4 months. Yeah, that's right. 4 months to file it, and 6 months from that same date. So not 6 months from the date you file it, 6 months from the last day you did work on the property. It's an incentive. It's supposed to be an incentivizer for the property owner to say, you're not going to be able to sell your property while this thing is sitting here, because a buyer is going to say, I'm not getting in the middle of that crap. If they just look at you and go, I don't want to sell my property, so I don't care what you do. What's next? A lawsuit. Unfortunately, that's what it is. It's a lawsuit. So it's either suing the GC if you're a sub, it's suing the owner if you're a general contractor, it's suing whoever you have to sue. But that's what happens when the lien expires. You sue. You want to go ahead and file your lawsuit before the lien expires. Having the lien filed does help you to sort of expedite your lawsuit, but that's what you got to do. You got to file a lawsuit. A lien is not verified by anybody. The clerk, when you file it, does not call anybody. They don't review the details. Your lien says my name, the name of the person who I'm filing the lien against, how much it is, what it's for, the address of the property, blah, 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 blah. It gets put in the system with all that information, and then it's done. It's just like a lawsuit. People can lie straight up on their lawsuit. I'll use you, Info Cura Concrete, since I can see your face on this. I'll use you as an example. I could go today and file a lawsuit for anything against you, and we've never met in person. There is no truth to it whatsoever. I could say you walked up in the street and punched me and I incurred $1 million in attorney's fees or medical bills. There's no truth to that whatsoever. I can still file a lawsuit. Same thing as with liens. Because liens are not verified by anybody, they only have enough juice to serve as a placeholder. So if you're going to act on it, you do have to get that judgment. Now, a judgment lien as opposed to a material means lien or a mechanics lien is actionable against the property to foreclose, but that has to be granted by a judge. So you have the material means lien. They don't do anything to fix it. You file your lawsuit, you get a judgment lien. That's the lien that gets filed that you can then go ahead and start foreclosing on property or trying to liquidate property to get your money. So, okay. And also liens, the note letter to tell somebody that they owe you money, collection, we're going to file a lien against your property. The copy of the lien itself that's going to be filed, those also are things that can be drafted up as templates and used over and over again if that's something that you think is going to be necessary. I will also say I don't know this specifically. I do not know in your industry what rights you have to turn somebody over to collections. There are some industries where you can do that, some where you can't. I don't know. That would be an option, I guess, as opposed to a lien. If you had the ability legally to turn somebody over to collections, if you have a contract that's not paid and a collections company is willing to do it, that'll ding their credit and all that kind of stuff. But again, both with liens and turning people over to credit, because they're not verified, you do have to be worried. I mean, the only thing you need to be aware of is that if for some reason the lien you're filing is not based in fact, it's not based in reality, they paid you, but you hate them, so you're going to file a lien anyway. There can be penalties associated with encumbering and clouding title on property if it's not proper. So make sure that when you're filing the lien, you really are owed money and you're owed that money for that stuff. Okay. 931. God, okay. So here is my information. I'm super technologically advanced, as you can see from my incredibly skillful slideshow, which I admittedly had to have somebody younger than me put together. So, but I have a really cool QR code that I made really big. So anyway, that'll take you to my page on our website, my law firm's website. That's my law firm's phone number, my email address, my picture in case you forget what I look like, and my QR code that will send you to my specific page on our website. If you want to reach out to me, if you're a current client of mine, thank you. And I look forward to hearing from you. If you have issues or questions about what we talked about today, like I said, I'm glad to answer general questions after this is over with anybody who's on this call or anybody in your organization. I can't answer specific questions unless I'm retained and engaged as a lawyer. So if you have specific questions about something in your business or how we deal with this employee or how we do this or that, we can get you engaged. We can pull you in. Van Winkle, we have 35 plus lawyers in 2 locations handling everything from tax, litigation, real estate transactions. I do business work and transactions, bankruptcy, class action litigation. We do everything. We do everything except domestics and divorces and estate planning and succession planning and all that. We do all of that stuff. So we don't do divorces or criminal work, but other than that, we do everything else. So if you want to come on board, please, be glad to have you as a client. If you have general questions for me, there's my contact information. Shoot me an email. I'll be glad to answer anything and work with you guys. And thank you for being part of this presentation of this group. I've worked with this group. Megan and I worked together to get you guys merged and converted when it was just the Transylvania and Henderson and everybody was disjointed. And now that you're the Blue Ridge Mountains, I helped with that process, and I'm glad to continue working with the organization. Great people, great industry. Thank you all for your time and attention.
Great, and thank you all for being here. This has been recorded and it'll get posted on our YouTube, most likely, that has previous ACE classes as well. So if you've ever missed any and you wanted to see the recordings, that lives on our YouTube. And if anyone has any questions, they can reach out to me, they can reach out to Megan, and Anderson's information is there. Thanks, y'all.
Thank you.
Thank you.